Ms. Slingerland?
Good morning.
Good morning.
May it please the Court, Marcia Slingerland for the Commonwealth. We are here in this case on the second interlocutory appeal in this second-degree murder case. Very generally speaking, the defendant is charged with 5 counts of second-degree murder stemming from a fire set to a dwelling house in Lynn back on February 24th, 1999, in which 5 people died. The defendant made really 2 sets of statements in this case. On the 27th of February, 3 days following the fire, she made statements to the Lynn police and the state police, eventually confessing to the fire. 2 days later, at her arraignment in Lynn District Court, she made some statements to a court officer as she was walking down from the courtroom where she'd been arraigned back down to her holding cell. She made some statements to a court officer.
Now, that's March 1st.
That's correct.
Okay.
This court has already reviewed the first decision that the judge made. The judge found that the defendant, based on her mental impairments, and there was significant testimony about the defendant's mental impairments, he found that the motion judge found that the defendant's waiver of her Miranda rights was not knowingly, intelligently, and voluntarily made. That decision was essentially upheld on appeal. In different words, this court found that the judge was well warranted in finding that her waiver was not knowing and intelligent based on certain findings he had made, that she didn't understand certain aspects of legal proceedings, the participants of players, and of that nature. This court overruled the judge with regard to the point at which custody attached, finding that custody attached later on during the statements the defendant made, so that some of the statements in that first set of statements on the 27th of February were suppressed and others were allowed into evidence.
Could you tell me, did the judge also conclude that she was incompetent to stand trial?
No, he did not. On March 1st?
Yes.
No. The defendant was examined on March 1st by Dr. David Swenson. And pursuant to General Laws, Chapter 123, Section 15, Dr. Swenson reported to the court that he had a doubt as to her ability to consult rationally with her attorney and to understand the proceedings against her. Based on that, he recommended that further evaluation, she be hospitalized pursuant to that scheme and that she be hospitalized.
Just for a little bit of background, where is she? Is she in jail? Is she in a mental health facility? Where is she?
As I understand it, she's in Framingham at this point.
And this is going on 6-7 years?
It is.
Now, on March 1st, when the judge made that, when Dr. Swenson made that statement to the judge, did the judge conclude that she was not competent to stand trial at that time, or did he send her back for further evaluation so that he could make that determination of competency?
Well, she was in Lynn District Court, wasn't she?
She was.
So there was no issue of competency, correct? To stand trial?
Not at that point. The record, you can infer from the record, Dr. Swenson he recommended that she be hospitalized for further examination. And in fact, on March 11th, he says he examined her again in the Salem Superior Court, presumably for an arraignment in the Superior Court. So, and I have included in my record appendix the competency evaluation that was submitted to the court at the end of March 1999. So there was eventually a competency evaluation completed.
And that report stated that she was competent.
That's correct.
But on the 1st, the doctor had a doubt that she was competent.
Right.
And similarly on the 11th.
That's right. He recommended she be further committed. But that doubt is what the statute talks about, and I'd suggest that that's what the judge was saying. I mean, you can have a doubt based on anything, but the statute requires for a finding of incompetency clinical findings, and that's what the extensive report that was done at the Taunton State Hospital.
But just so we understand, it's at the Lynn hearing in 11 days, it doesn't have to do with competency to stand trial. It has to do with whether he had the present ability to consult with her attorney. That's what's going on at the arraignment, correct?
Yes.
That's what Swenson is talking about.
That's correct.
And he's saying there was a doubt, using the statutory language, that the defendant maintained sufficient present ability to consult with her attorney to a degree of rational understanding.
That's correct.
That's what's going on in Lynn.
Yes. And so she's evaluated to determine whether that's in effect true.
And so he recommended that she become hospitalized, and she was.
That's correct.
But she was in fact arraigned in the Lynn District Court, wasn't she? Or we don't know that.
The record is not clear on that.
But the judge in the district court did not make a determination that she was not competent to stand trial at that point.
There's nothing in the record that indicates that.
Okay.
Well, there wouldn't be anything in the record.
Well, if she was going to be arraigned and she was not competent, there could be, couldn't there?
There could be.
They could defer her arraignment if she was not competent to be arraigned.
Well, competent to be arraigned, yes.
Yeah.
Well, now, as I understand it, the judge has suppressed everything because it's not voluntary?
That's correct.
Everything?
Everything.
Well, everything at that...
There were statements made to the
on
court
on
office.
March
1st.
1st. Okay, so
That's
it's not
right.
everything, it's a March 1. Right?
Originally, he had suppressed certain statements made to the court officer based on the fact that she was a government agent and she shouldn't have been questioning the defendant. However, originally, she had made some spontaneous statements. There was a conversation, a casual conversation with the court officer. It's following her arraignment, is the way it's indicated, I believe, in the record. And those initially were not suppressed because they were not designed to elicit an incriminating response. At oral argument on the last interlocutory appeal, defense counsel raised for the first time the possibility that these statements were involuntary. And this court declined to address it at that issue at that point, but allowed the defendant the opportunity to go before the trial court, which the defendant did. The parties stipulated below that no additional evidence was necessary and forwarded transcripts of two defense experts that the judge had largely credited in the first motion, along with testimony by Dr. Swenson and testimony by the court officer.
May I ask, would you agree that what was before the judge was the following: that the defendant had a history of hospitalizations, psychiatric history, epilepsy, saw spirits, thought that her cell was haunted, saw auras around people, was mentally retarded, schizophrenic, engaged in magical thinking, fixed delusions, auditory hallucinations, thought she had a tribal council that advised her, and that the judge concluded that there was a tenuous connection to reality, poor judgment, and unstable affect? All of that?
On March 1st.
Yes.
He had before him the information he had heard at the first suppression hearing, which was, yes, there was all that. The fact that she saw auras, she had a chronic condition, I think the judge was aware. She had a certain set of beliefs that was perhaps not mainstream. She believed in certain Native American rights, and that she had a tribal council that advised her. So she had this chronic state of how
that was in her head, right?
That was what she reported she believed. That's right.
Yeah, I mean, it was fantasy.
It was her belief.
She looks awful sick to me.
Well, she has been diagnosed as being mildly mentally retarded, functionally illiterate, and suffering from schizotypal personality disorder, which is characterized by psychotic episodes. On March 1st, when Dr. Swenson examined her, she saw auras around the defense attorney and the doctor. However, she accurately reported that she refused to take medication. There's a number of things that she reported: a history of epilepsy, a psychiatric history. She told this. She reported that her cell was haunted. She said that they think I set a house on fire and that her son was innocent.
What do you say the judge did wrong? Are you trying to get us to decide something that's factually based differently than him? Or do you say, where's his error of law?
His error of law is his conclusions are not supported by the facts he found. He did not find that her statements were the product of her mental impairments.
He found that there was a reasonable doubt. I mean, you've got the burden to prove beyond a reasonable doubt that these statements were voluntary.
But the law is also clear that the statements must be the product of her mental difficulties. What he did was he did not make any findings as to her condition at the time that she made those statements. And the transcript was clear that there was nothing unusual about her demeanor. It was fine.
Ms. Lingerland, may I just ask you, did you go back in and ask the judge to make specific findings? I mean, it's your burden, right?
Right. Well, there was a motion in the trial court before the judge.
No. After the judge's findings on this time come down, which is October, am I correct? It's October 26, 2005?
That's right. I believe the defense counsel asked him to make...
What have we been doing for 2 years?
The case was docketed in this court in July of 2006.
Well, what happened between 2005 and 2006?
They were assembling the record for appeal.
Okay. So, leaving that aside, did you go back and ask him to make specific findings? I mean, if your Justice Glaney's point is, what's the legal error? If your claim is that he didn't make specific findings, don't you usually go back to the judge and say, Judge, could you make these findings? These are the findings. I mean, did you submit proposed findings?
I think I was not the counsel on the trial court, but I believe that the parties submitted memoranda, which I've included in the record appendix, setting forth their positions, what the findings should be. The judge made certain findings, and they're in his decision, but they do not support his conclusion that her statements were involuntary. In other words, the product of her mental impairment.
Is your argument that that the linchpin of the judge's finding of involuntariness is a statement that Dr. Swenson made at a competency hearing to the effect that he had a doubt that lingering in his mind that she was competent, and that the judge picked up on the doubt that she was competent and somehow morphed that into a reasonable doubt that the statement was voluntary? Is that the essence of your argument?
That's part of it. He uses that doubt to support he makes findings. She's mildly mentally retarded, functionally illiterate, has this schizotypal personality disorder, and he says in his decision that is not enough to conclude that her statements made to the court officer were involuntary. However, that doubt that Dr. Swenson had confirms that the statements were not voluntary. And to the doctor's doubt, he adds his prior finding that Drs. Rosemarin and Kelly had concluded that the defendant had not made knowing and intelligent and voluntary waivers.
A couple of 2 days before. I mean, we're not talking about something. All of this testimony, or a lot of this testimony, related to her state on February 27th, right? Her mental state, and so we're talking 2 days later. He has all of that information, findings with respect to February 27th. Right. 2 days later, another doctor says, I have doubt as to her competency on today's date, and she should be committed.
But the judge found that her statements 2 days earlier to the police officers were voluntary. And this court specifically pointed that out, that the judge had not been warranted and would not have been warranted in finding that the statements were involuntary, and she suffered from essentially the same condition that she had.
So the Miranda was not voluntary, but her statements on February 27th were voluntary.
In the sense that they were not a product of her mental illness.
Right.
In fact, the judge here, as of March 1, doesn't just find that there's a doubt about competence. He says she was incompetent. I think that's probably not correct, because he's saying Dr. Swenson found her incompetent, but that is in fact not the case, correct?
That is correct. He does say at some point in his decision she was seemingly incompetent and not competent.
So is your argument that because he had earlier found that her statements before, 2 days earlier, were voluntary, there isn't enough in this record to support the change in the finding that now, 2 days later, the statements are involuntary?
There's nothing to suggest...
Is that your argument, essentially? Or
It is. There is nothing really to support his finding that they're voluntary, particularly given his careful...
Involuntary.
involuntary, I'm sorry, particularly in light of his careful conclusions, which are on page 68 of the record appendix. That's his first findings with regard to voluntariness. During the police interrogation, in fact, the defendant would go off on tangents involving her Native American and other religious beliefs, some of which are irrational. But the judge said, you know what, the police were able to refocus her. She appeared...
Ms. Slingerland, excuse me for interrupting you. Let me ask you this. It seemed to me that part of what the judge was doing is saying it's one thing if you're being interviewed. It's one thing if you're being interviewed. This court officer was not interviewing this woman, correct?
That's correct.
She is, and I don't want to belittle, but she's sort of mouthing off, right? She's in a different situation. She's come before a judge. I mean, it may be that you are correct, but it strikes me that what he was doing in the earlier cases, even when people think, you know, it seems to me that it's conceivable in a very carefully constructed interview, you might be able to get somebody to focus. Whether that's the same, whether that necessarily means that when somebody's just been, you know, handcuffed and walking down with a court officer to a holding area, you know, when she is the court officer, I think is a woman, correct?
It is, yes.
Is clearly not interviewing this woman.
Correct.
I mean, she really didn't do that.
But the judge really didn't address anything about that. He just said he had a doubt, really not setting forth any factual bases. There was nothing about her demeanor, which was unremarkable. She initiated this conversation, the defendant. The court officer simply said, "Excuse me," which the judge found earlier had been a reflexive response to her statements. She was not emotionally upset. She cried and sobbed earlier. I mean, it's a much stronger showing, I would suggest, as to voluntariness with the court officer than it had been earlier.
Well, in a sense, what we're faced with is a beyond a reasonable doubt test, so that, and anyway, your time is up, so thank you.
Thank you.
Mr. Natola.
May it please the Court. Hilton's statements can be attributed largely to her debilitated condition. That's what the judge wrote, and it's on page record 106.
May I ask you this, ready to follow up on the questions that I just asked Ms. Slingerland? There's no question in this record that this woman has some kind of mental illness, but it is possible that people, and we know this, the case law is very straightforward, that the fact that you have a mental illness doesn't necessarily mean either that you're incompetent, and it certainly doesn't mean that statements that you make are not voluntary. So what is it about the circumstances as she's being led out of the courtroom and talks spontaneously to the court officer that would suggest that that wasn't voluntary as opposed to the police interview that was 2 days earlier?
Well, respectfully, Your Honor, I think the focus needs to be broader than that, because the standard of review is in the totality of the circumstances.
Correct.
So the totality of the circumstances must include the findings that the motion judge made about Ms. Hilton's condition a few days earlier.
Correct, but would the totality of the circumstances not include that 2 days earlier, talking about the very same substance, there's a finding that those statements were voluntary?
Yes.
Okay. So then I'm saying, what is different about this encounter, leaving aside competency, correct?
I think that I suggest that really the fundamental question that the court needs to answer is what was different is the following. And I believe it was Justice Cordy that asked the question about the linchpin, or maybe it was Justice Spina. And I suggest that the linchpin of this case is Dr. Swenson's finding on the date of the arraignment that there was a doubt as to Ms. Hilton's competency to...
It's not a competency He didn't say anything about competency. Did he actually say anything about competency, or did he say that at least I've only looked at Judge Bornstein's findings.
There was, I believe that
There was a doubt that she maintained sufficient presentability to consult with her attorney.
Right. And
Isn't that what?
that's part of the legal standard of competency, though. Either one must.
But what does it have to do with voluntariness?
As the court, the key case that the court needs to look at, most respectfully, is the Hunter case, which is cited in my brief.
Yeah, I have the Hunter case, and I think that there is a difference. I mean, we've said that whether the defendant is competent to stand trial differs from whether he's able to make a voluntary statement, but the two do share common attributes, correct?
Yes.
But, I mean, isn't this very analogous to the finding that Ms. Hilton was not confident, was not able to understand her Miranda warnings, but that's different from saying her statements on February 27th were the product of her mental illness. I mean, isn't this similar? She may not, there may be a doubt as to her competence to consult with her attorney, but that would be different than whether the statements volunteered to the court officer were the product of her mental illness. And in fact, the judge had reviewed them before and didn't seem to have any problem with them the first time around.
You're right, Your Honor. And that's why I go back to Dr. Swenson's finding. It's that additional fact that the judge had on March the 1st that he didn't have on February the 27th, that when added to the information that he had regarding the 27th, tipped the balance, I respectfully suggest. And I suggest further that if he had that information, in other words, Judge Swenson made that finding within minutes of Ms. Hilton making the statement to the court officer. Of course, it would have been impossible for there to be such a finding on the 27th because she was in a police station house. But I suggest that if the motion judge had the same information about Ms. Hilton's statements on the 27th, he would have suppressed everything on the grounds of voluntariness. And most respectfully, I think he would have been justified in doing so.
Was Dr. Swenson expressing an opinion as to Ms. Hilton's competency when he used the word doubt? Or was he saying, you know, I've got some unanswered questions here. I would like to have her examined further and to resolve those?
I think it's probably the latter, Your Honor. But certainly, as this court said in Hunter, doubts concerning a defendant's competency, and that's what, I mean, we were talking about competency on March the 1st. And although Dr. Swenson clearly never said that Ms. Hilton was incompetent to stand trial. He never said that. So he did say that there were doubts. And what this court said in Hunter, coincidentally based on a statement by Dr. Swenson in that case also, which was identical to the statement he made here.
But the doubts that he had were expressed in the context of his desire to have further evaluation so that he could resolve those doubts.
Not so that he could resolve the doubts, but so that they could be resolved in the context of a fuller examination. And of course, they were resolved favorably to the Commonwealth, I suppose, in as much as Ms. Hilton was found to be competent by the people at Taunton State.
Mr. Natova, haven't we said that statements that are attributable in large measure to a defendant's debilitated condition, such as insanity, are not the product of a rational intellect or free will and are involuntary?
Yes.
And that's your position, isn't it?
That is my position, and that's what the motion judge found at page 106 of the record appendix here, when he said that Hilton's statements can be attributed largely to her debilitated condition. And I respectfully suggest that equates with the product of her mental illnesses.
But he says, given that she was incompetent, well, no one had found she was incompetent on page 105. Consequently, given the conclusion that the defendant was incompetent to stand trial on March 1, and that she made a knowing voluntary, and she failed to make a knowing voluntary and intelligent waiver of her Miranda rights, her statements were not voluntary. Well, the first of that, he in the first decision, he said that did not make them involuntary. And the second of that, he's just wrong as a factual matter. She wasn't incompetent. I mean, we don't know whether she was competent or not, but no one had found her to be incompetent.
That's correct. Nobody had found her to be incompetent.
One of the difficulties with Judge Wallenstein's findings and conclusions is on the prior page of his decision. It seems to me that he more accurately reflects, maybe not because we don't have it, but since Hilton seemingly remained incompetent, so on the one hand he's saying she seemingly remained incompetent on that day, and then he says, because of that I have a reasonable doubt.
And I think
he's not saying, he's saying I have a reasonable doubt.
And I respectfully suggest that that's the key. On page 21 of the Commonwealth's brief, they write, contrary to the judge's findings, however, Dr. Swenson did not conclude that the defendant was incompetent or seemingly incompetent to stand trial. The judge wrote, what he ruled was that the testimony of Dr. Swenson confirms that a doubt existed as to whether she was capable of providing voluntary statements. And he says a little later that she seemingly was incompetent to stand trial. And I suggest what that language clearly is the judge drawing an inference based upon Dr. Swenson's testimony and based upon the other evidence that he had heard.
But I thought you just told me that Swenson's testimony was not an expression of opinion that he had in his own mind doubting her competency to stand trial, but the need for further evaluation.
That's right.
The judge misassessed what Dr. Swenson was testifying to.
I'm not sure that he did, and this is why I suggest that that language on page 104 of the appendix shows that he drew an inference from Dr. Swenson's doubt of that he testified to. That was his opinion, that he had a doubt about her ability to consult and so forth, that the motion judge drew the inference by using the word confirms that a doubt existed. And I suggest that that's the heart of the motion judge's ruling, not that she was competent or incompetent, because that's not the issue here. The issue here is whether or not the Commonwealth has proved beyond a reasonable doubt that her statements were voluntary. And where Judge Bornstein ruled that Dr. Swenson's testimony confirms in the judge's mind that there was a doubt, I suggest that's enough. Now, when he goes on to talk about seemingly incompetent, again, I believe he's drawing an inference, but it's really the key element is, in his mind, Dr. Swenson's testimony that confirmed a doubt in the judge's mind as to whether or not she was capable of providing assistance to her attorney and providing voluntary statements at the time.
Mr. Natola, could you help me just... You made a point, an interesting point, that Judge Bornstein had some additional information, namely the sort of psychiatric evidence about her mental capacity. In our earlier decision, and I again haven't gone back to look at the record, it says the judge found that the statement, and we're now talking about the police station statement, found that the statement was not the product of defendant's mental illness, but she had been coherent and rational. You know that part of the opinion. Yes. At that time, did the judge have before him the testimony that he refers to now in this decision at page 11 of his decision, which was Record Appendix 105, that according to the testimony of Rose Malin and Dr. Kelly, as well as all the available evidence, Hilton failed to make a knowing, voluntary, intelligent waiver of her Miranda rights during a police interrogation.
He had the information about the psychiatric and psychological testing and that testimony before him. He also had, at that time, of course, the testimony of Dr. Swenson before him. And he was very careful, I suggest, to separate those things out because he could not apply Dr. Swenson's opinion or his testimony to what happened on February 27th, because Dr. Swenson did not examine Ms. Hilton on February 27th. But the judge had all of that information on the record in front of him.
So I take it in summary that what you have is some events occurring at a police station on February the 27th. Some psychiatric experts thereafter, not on February the 27th, taking a look at what had happened in her history and so on and so forth, and testifying as to whether or not they thought she voluntarily waived her Miranda rights. And then you have an event on March the 1st where the psychiatrist is actually looking at the defendant on March the 1st, correct?
Yes.
Okay.
That's exactly the sequence. So,
I'm sorry.
Yes.
Mr. Natola, isn't it the case that back on February 27th, she said something not dissimilar from the remarks on March 1st? In other words,
Yes.
she said something about her son would hate her and never forgive her, right?
that's exactly right.
Which the judge found to be voluntary,
Yes.
right?
Yes.
But on March 1st it wasn't?
That's right.
Okay.
What do you say changed between the two dates?
Again, Your Honor, I suggest that the only thing that changed, and I think it's clear from the record, the only thing that did change is Dr. Swenson's examination of her on the 1st and his opinion. And that's why I suggest that I agree that that is the linchpin of this case.
So both of you agree that the linchpin or the key is that Dr. Swenson said he thought she needed a competency evaluation, that she may be incompetent.
Yes. Yes, that was the added element.
But then that report came back that she was competent.
That's right. That's right.
I take it that the transcript is here as part of the record appendix?
It is.
It is.
It appears in the docket, 10 volumes.
It was lengthy, so that sounds like it.
10 volumes of the Swenson testimony at the Lynn arraignment is what I'm asking
No, Your
for?
Honor. Oh,
No.
I don't believe that I don't believe that was ever preserved. What Justice Green is
No, I
referring to
understand
is
that
No,
the
that's the
hearing,
first
the
motion.
Borenstein hearing.
Well, we can't worry about that because you two agreed to submit it to the judge on the existing transcript.
That's right.
Without regard to anything that you might either obtain or reconstruct in Lynn. Okay.
Thank you, Mr. Natona.
Thank you.